Hello, everyone, and welcome to another episode of Ask the Attorney. My name is Blair Clark, and with me, as always, is David Sobel. David, how are you doing this evening?
Good, Blair. How are you? It's good to see you again.
Good, thank you.
Yeah.
Doing really well. So for those of you who are tuning in for the first time, what we do is we run down a list of questions that have been collected by David's office. So each week, people from all over the state of Michigan and Ohio and all over the nation, really,
Right.
sometimes globally,
Yeah.
reach out to David for real estate related questions. So questions that are related to real estate and contracts and finance and estate planning, all sorts of different things. So David's clerks at his office, they take like the top 7 to 8 questions every week. And then we run down the questions. I ask the questions, David provides the answers. There's always tons of wisdom. So if for some reason you're welcome. If for some reason you are not viewing, excuse me, this video on YouTube, excuse me, check out David's YouTube channel. You can just go over to YouTube and in the search bar, just search for David Sobel, Sobel Law, Proven Resource, and his YouTube channel will pop up with all sorts of topics just like those that we're going to dive into tonight. But before we get into the questions, David, I want to give the people an opportunity if they would like to reach out to you to ask you or anyone in your office their questions. How can they contact you?
You know, I want to tell you real briefly, but before I do, you know, and Blair in her own right is now a seasoned investor.
Sorry.
And yeah, and Blair and I met at one of the almost like a meetup, and then through this new Michigan Real Estate Investors Network, the network, we've worked together quite closely, just doing these videos and also talking about deals. And so today we were just talking before we start that you're just finishing up on a project that you hope to flip shortly, correct?
Yes. Yep.
Very good. So when we talk, I'm giving you the real estate background. I'm also I've been investing for years. I own quite a few properties and have owned a lot of properties over my career. And so when I talk to the audience and to the viewers, I'm telling you not only as an attorney about information that is important legally, but also I have a perspective that's just a practical perspective of, from experience of dealing with these properties. But when I first met you, Blair, you were just getting into, I believe, your first property, first or second, and now you're onto your, like, you have a handful or two of properties, and we were just talking before this that you're finishing up on a project, and so this afternoon is a Sunday afternoon that we're doing this. But I want to just say thank you, of course, for taking time from your very busy schedule, which is not only to fix and flip and to hold, but also you have a young family that you're raising as well. So you're very busy. And I do want to tell you, I really appreciate you, and I appreciate the time that you take to do this for everybody, because you are also giving a lot of wisdom from your experience and your time away from your family to do this. So thank you.
Absolutely. Absolutely. Thanks, David. You're going to make me cry. I'm going to have to go find my tissue.
Don't cry. Don't cry. Right. Get that tissue we were talking about. Okay. In the meantime, so just to answer your question, though, now that we just went off the aside, yeah, so I have a boutique real estate and finance law firm located in Michigan, Southeast Michigan. We handle all of Michigan as well as the northern parts of Ohio, Cleveland, Columbus, and some would argue, Cincinnati is not really the northern, it's really southwest Ohio, but we handle mostly Michigan and northern Ohio for real estate matters, finance matters, financial disputes and contract disputes related to real estate and probate. So the best way to reach us is 888-789-1715, and also you can go into our any URL in a search engine, type my name, David Sobel, S-O-B-L-E, or type in Proven Resource, and the content that we have, which we've been working on for over a decade now, decade worth of content for our friends and our family and new members of our clientele, as well as old members of our clientele. It's all available online, and that's how you really reach us, is just put in my name or put in Proven Resource, and we should come up, and if we don't, we need to know that right away. But it's 888-789-1715. That's the best way to reach us. Okay.
Good. All right. Well, let's jump into the questions for this evening. We have our first question from Deborah in Wyoming, Michigan. And Deborah says that recently an investor gave her a cash deposit to purchase her property. However, no written contract was signed and no receipt was given. A month later, this investor called to cancel the deal. Do I have to give the money back in reference to that cash deposit? From Deborah in Wyoming.
Well, I mean, some would argue if you're from from the perspective of a real estate investor, you in this situation, you would say, yes, I want that money back, because it should have been dictated, the terms of that deposit should have been dictated by a contract, something in writing. Mm-hmm. But the homeowner who's been giving the money, if it's not in writing, shame on the real estate investor, because it could be argued, well, you weren't really doing a deposit for the purchase of the property. You may have just given money to hold the property, just hold it for a very brief period of time, almost like an option. So if it's hear me out, I mean, I don't want to complicate too much, and we always go down these slippery slopes. It's never straightforward in law. It's not like science. It's not like engineering or math. It's never linear thought. There's some law has a number of different areas that we, gray areas that we can discuss. And in this situation, in general, if the agreement was to hold the property for, let's say, a week, well, that doesn't even require a written document memorializing what the parties agreed to, because it's less than a year. Anything less than a year under what we call the statute of frauds, Michigan statute of frauds, does not have to be put in writing. So it can go both ways. It depends who you're arguing for. Okay. Hopefully the real estate investor didn't give a lot of money. Maybe it was 100. A lot of, as you know, Blair, a lot of real estate investors will put down a minimal amount just to hold a piece of property.
Right.
It should be in writing. If you want to avoid any confusion, you should have everything in writing and memorialize it. And if a real estate investor is looking to get that money back, it must have been more than just $100, right? Or $10, because a lot of people hold stuff in this community, in this real estate investing community, for 100, maybe $200. So if it's $1,000, shame on the investor, right? They should have had it in writing. Mm-hmm. I can see it both ways. So there's no real 100% answer on that, but it's best if it's in writing. If for all intents and purposes, that's the best way to make sure there's no confusion. Okay. Okay.
Well, just expanding on this, what if this person, I'm assuming that they're an investor because that's a pretty good assumption, but what if this person, oh no, it says recently an investor.
Yeah, they are an investor, right?
Said that right in the question.
That's okay.
So what if this investor pursues the return of his money? Like, what would her path be? I mean, obviously to reach out to an attorney like yourself, but
well, it's, like I said, it's going to be, it's one person's word against the other. Mm-hmm. The argument on behalf of Deborah would be, hey, he gave me the money to hold on to the home for 1 week. And if he didn't come back, I could keep the money.
Sure.
And you don't have to have that in writing, because that was the agreement. It's less than, the term for that was less than a year, so it doesn't have to be in writing. Mm-hmm. The investor could say, well, I gave you an earnest money deposit to purchase the property, and I was going to complete the purchase within the year, but it's not in writing. So what really happened here? I'll tell you, if any party went to go get an attorney, ultimately, if you had to go to court for $1,000 or whatever the amount, most people would split split the money. I mean, I know that there's a book called Never Split the Difference. Well, that author, when he doesn't go to court every day, but when you go to court every day and you have to pay for litigation, you ultimately, in the end, if you don't go to trial, parties usually are splitting a little bit more than the difference, right? Mm-hmm. They're long and short on this one is, if it's 10,000 or 1,000 or $10, you know what, that investor ultimately, because we deal in real estate every day, if you're a real estate investor going out to the public, everything's going to be kind of, if you had to go to court, it's going to be construed against the investor, not against the homeowner. Okay. So the best way to avoid confusion, and we talk about this quite often in so many videos, is have a contract, have something, even just on a napkin with two people signing it would be better than nothing.
Yep.
Even a contract on a napkin is still a contract. Remember that. And I hate to plug a book. I mean, my books are all free, but the book that I think of when I'm telling you, it's called Shading. And it's just about how to do business. Usually it's really how to do business with family and friends. But in general, it's the same thing. You always need a contract. Always put things in writing. Okay?
Yeah.
What would you do? I mean, you're an investor. How would you look at this?
Well, in this scenario, I would say that the investor lost the money because from my perspective, number one, I wouldn't do it without anything in writing. And I did once with a notebook paper. We wrote up a contract because we had a property under contract. Someone, just long story short, someone wanted us to assign it to them, and I didn't have the contract on hand, and they were willing to give me a deposit for that property right then and there. But for me, it was like, I'm not taking your money without anything in writing. So it wasn't even, anyway. So yes, so I've handwritten a contract before and we signed it. Anyway, in my perspective would be, as the investor, you put that deposit down so that you were purchasing the time. You were renting that person's time, and you kind of held that person's time up. This seller, Deborah, she kind of held off her rights of pursuing any other type of sale.
Right.
She held that for that person, and so that time is valuable. She has lost some time that she could have. And maybe she never had the intention to, but anyway, she lost potential time that she could have had it on the open market. She could have been talking to others. She could be further along in her sale process, but you, the investor, you held her up, and now you owe her some consideration for that.
Right.
In my opinion.
Right. And so what that really is, Blair, is you basically defined what to me sounds like an option. He bought an option to purchase, right? And so you don't really need that in writing. It's best with anything in real estate, it is in writing, okay? But again, he bought the option. He bought the time to hold up the property, okay? That's my argument on behalf of Deborah. The argument that the investor is going to make is, no, that was an earnest money deposit. That wasn't even an option. So it's a great example. A lot of people come to these videos and they look to these videos to get answers. And I know sometimes, I've gotten calls where somebody says, I listened to your video, but you really didn't give a definitive answer because honestly, sometimes there's no definitive answer. There's just arguments. These arguments can be made on both sides, but it does show and illustrate and demonstrate that the importance of why things have to be placed in writing. And that would really be the best lesson from this question. Okay.
Yep.
So that's it. That's where I'm at with this, but good question nonetheless. Right?
No, I agree.